Good afternoon. Welcome again to the Court of Criminal Appeals Eastern Section January docket. Our panel has changed a little bit for the first case this afternoon, and to my right is Judge Christy Davis, who's from the Court of Appeals, who's agreed to sit in with us on this case. And of course, I'm Rob Montgomery, and to my left is Tom Greenholtz, who's also on this court. Now, Madam Clerk, do we have any preliminary matters for? All right. Would you call the first case in for the afternoon docket, please?
Glenn Larry Brown Jr. versus State of Tennessee.
And if I didn't state that earlier, let us know if you're the appellant, if you want to reserve any time for rebuttal.
Good afternoon. May it please the court. My name is Chelsea Moore. I'm here on behalf of appellant Glenn Brown on appeal from the denial of post-conviction petition. I'd like to reserve 5 minutes for rebuttal. This case began when Mr. Brown was arrested on March 28th, 2016, after picking up a friend. Mr. Brown didn't know until it was too late that this friend brought with him a gun and drugs. When the two men were driving around, Mr. Brown was stopped for speeding. Officers pulled Mr. Brown out of the car to separate the two men. When Mr. Brown was put into the back of the cruiser, he told the officer, "There is a gun in the car. It is not mine, but I wanted to let you know." That officer begins to yell up to the other officer who's standing next to Mr. Brown's friend, who is still in the car. Mr. Brown is in the back of the cruiser. The officer yells up to warn the other officer about the gun, at which point Mr. Brown begins to shush the officer because Mr. Brown does not want his friend to know that he just tattled on him. This is all depicted in the officer's body or cruiser camera. This is on video. It is clear as day that Mr. Brown says, "The gun is not mine." Mr. Brown did not mention the drugs because they were in a case underneath the passenger seat. He was unaware of them. These are facts we know from Mr. Brown's post-conviction hearing testimony. Mr. Brown maintained his innocence from the moment that the officer took him from the car through pretrial proceedings when Mr. Brown wrote the assistant district attorney a letter asking for leniency in exchange for his testimony against the co-defendant, through his attempt to testify on his behalf at trial, which was obviously denied to him as alleged in the brief, and then through post-conviction proceedings afterwards. Unfortunately for Mr. Brown, he was saddled with an attorney who was unwilling to do the work necessary to defend her client. I've raised two primary issues today.
That's a pretty harsh condemnation, and in fact, that kind of tone is replete throughout the brief. Is that really appropriate here? Do we need to have that harsh condemnation, or can we talk about it in more neutral terms that would be more befitting the bar?
If Your Honor would prefer I tone it down, I can.
I would, please. Thank you.
I would just point out that this is one of the most egregious errors that I've seen.
That's true. That's true. And look, I mean, I understand zealous advocacy, and you do very well at zealous advocacy. You do. I mean, I've had the pleasure of watching you previously. I don't know this trial counsel, and it's entirely possible that there was deficient performance. There may not have been. Sometimes, though, I wonder if we all don't go there but by the grace of God, and so I wonder maybe if we can discuss the issues seriously and intelligently, maybe in a different way.
Let me know if I get too harsh.
You're fine. You're fine. I'm not admonishing anything. It's just I think that would be a tone that I would appreciate, and I'm not speaking for anyone else, just for me.
Okay. So the first issue that I raised was the trial court's error in denying post-conviction relief, largely based on the ineffective assistance of counsel claim. The second issue was the trial court ignoring the issue of the trial court denying Mr. Brown his right to testify at trial. This is raised as a separate issue, but also under the IAC issue, because it is a non-structural constitutional error. And the state has argued that the independent moment issue has been waived. Obviously, in my reply brief, I disagreed, because if waived, then it denies him the opportunity to litigate this issue, but it is also unreasonable to expect trial counsel to raise an issue for which she was at fault. So it's unfair to Mr. Brown to hold him to raise issues when he was represented by counsel.
Well, I mean, the doctrine of waiver here in the post-conviction context is where you had an opportunity to raise a freestanding claim in the trial court or on direct appeal, but failed to do so. A statute bars then you to raise it, not you, but the petitioner to raise it in post-conviction. And that's simply because post-conviction remedies are not a substitute for appeal, right? As it goes. And so where counsel doesn't raise it but should have, we have an independent ground under the Sixth Amendment. But talk to me about the separate standalone issue of a constitutional violation by the court. Because I think in Thompson versus State in 2018, this court held exactly and almost on all fours with the issue that may be before the court today, that it was waived. The standalone issue is waived. Now, the ineffective assistance of counsel issue may not be waived, but the standalone issue may be. So can you help me understand about why the standalone issue is not waived under the statute?
I would argue that the post-conviction statute specifically lays out that constitutional errors shall be raised on post-conviction, and that this is a constitutional error. It was deprivation of his constitutional right. There was an obligation.
They have to be raised in a particular way, though, correct?
Correct.
Okay, so how, if you can help me understand about the way in which this wasn't raised pursuant to that same set of statutes, how is this not waived?
I would argue that it is not waived because it is a constitutional error. It did happen, and while there was an opportunity to raise it on direct appeal, it just wasn't. And this is the opportunity for him to raise these constitutional errors. And in fairness, due process should allow him to independently raise this claim, because the trial court had an obligation to maintain it, to uphold his rights, to protect his rights, just as much as defense counsel, just as much as the state, honestly.
Do you think our previous cases are in error?
If they contradict me today, then yes. I would say that.
Do you have anything other than that, respectfully?
Respectfully.
And I'm not, making light of the answer,
Right.
but I mean, I understand your opinion, and that's sufficient. But do we have anything else to indicate that our previous cases are in error?
I cannot answer that question at this time. If the court would like to hear.
That's okay. That's okay. I
From me
appreciate
after.
it. Yeah, we can move on.
Okay.
I'm sorry.
So,
Thank you.
But once again, if the standalone moment issue is waived, then I believe that would add to the argument of prejudice on trial counsel, because trial counsel failed to raise the issue on appeal and failed to protect her client's rights at trial and subsequently after. But the ineffective assistance of counsel claim arises much earlier than appeal, obviously. Pre-trial, trial counsel filed some motions, including motion to suppress and speedy trial motion. But both of those motions were filed within a week of the trial date. And trial counsel went on vacation and made no attempt to set these motions for hearing. At the trial court level, the trial counsel argued that these were legitimate motions, that her client was entitled to a speedy trial, that she was prepared to go forward, that the state failed to call in a jury, and that just because co-defendant's counsel was not prepared to go forward, it should not affect Mr. Brown's right to a speedy trial. In the same breath, she argued that this motion to suppress needed to be argued prior to trial. At the post-conviction hearing, trial counsel testified that she never actually intended on moving forward on the original June 19th trial date, that she strategically filed these motions because Mr. Brown wanted to assert his speedy trial right. Mr. Brown was ready to go to trial because he knew he was innocent and he wanted to get out of jail. But she did not want to go forward on that date. Therefore, she filed this motion to suppress and agreed with the state prosecutor that they would not call in a jury and they would not proceed to trial on the 19th. However, or not however, those two statements are in direct contradiction. Her statement to the trial court, we're ready and willing and able to proceed today to trial, we want to go to trial today, and her post-conviction testimony that she never intended to proceed on that date, are one of the many examples of her contradictions, of her lack of candor and lack of communication with the court and with her client. If she was not ready to go to trial on that date, then she should have informed her client and spoken with her client. She did not do that. Then, proceeding on to trial, once trial began in September, she began her opening statement by telling the jury that her client was guilty, but that they would hear a reason why. She made promises that she never, according to her post-conviction testimony, never intended to keep, and she said that she was trying to build credibility, but, as this court has noted in previous cases, unfulfilled promises directly contradict attorneys' credibility, cause issue with the jury. So by her promising something she never intended to fulfill, she was already losing ground with the jury. Not to mention the fact that her statement that Mr. Brown was guilty and he was forthcoming with the officer and admitted owning the gun was just incorrect, directly in contradiction with what Mr. Brown actually said. So she repeatedly overbore the will of her client, the wishes of her client. He was not guilty. She told the jury that he was guilty. He wanted to testify. She didn't call him. Over and over and over again, she put her client's wishes and his directives, of little there are, on the back burner in favor of what she wanted to do. And I argue in the brief that her misstatement of fact is evidence of her lack of preparation, lack of investigation, because if she had watched the Cruiser video, she would have heard him say, "It is not my gun," rather than what she told the jury, "It is his gun." She would know that. The lower court erred in finding that she was credible because there is ample evidence directly in contradiction with her post-conviction hearing testimony. She testified about the video, which I've discussed at length. She testified about Mr. Brown's letter to the assistant district attorney. She claimed at post-conviction hearing that that letter admitted guilt to the gun, but in fact it did not. It said the direct opposite. It was not my gun, not my drugs. They were the co-defendants. I'm willing to testify against him. At the time of the post-conviction hearing, I did not have that letter, but the state provided it afterwards, and it was late filed as an exhibit. So your honors can review the letter. The trial counsel also claimed that this was a strategic or tactical decision because she planned on presenting evidence to justify a felon in possession of a weapon. However, at post-conviction, she was unable to articulate what defense she planned to put on in a case where a gun was found in a car and there was no imminent threat. So there was no self-defense argument. There was no legal defense to felon in possession of a weapon. Yet that's how she testified that's why she misstated evidence in her opening and then repeated it in closing. As to Mr. Brown's desire to testify, she claimed that he never intended to testify. Yet, he says in the letter to the Assistant District Attorney that he wanted to testify. He says during the jury out moment hearing that he wanted to testify. She announces in front of the jury, after the co-defendant has testified, that she planned on calling her client and wanted to know whether that should be done today or in the morning. So she tells the jury, I'm going to call my client. And the next day, another unfulfilled promise. She rests with not only not calling her client, not calling anyone to explain the events of that day. Mr. Brown was prejudiced by these actions because he was unable to present any defense. He was unable to tell the jury what happened that day. And he was deprived of his constitutional rights under the Tennessee and federal Constitution. I'm out of time, so I will finish up later.
Good afternoon, Your Honors. May it please the Court, Ben Ball on behalf of the state. As I was listening to my friend on the other side's argument, it occurred to me that there's one really inconvenient finding from the post-conviction court for the petitioner, and that's the post-conviction court's credibility findings. Because essentially, the argument today is an attempt to sort of to relitigate that finding. And I don't want to belabor the point. I know this court is very familiar with what its job is relative to the trial court. And it's the trial court's, or the post-conviction court's job to judge the credibility of witnesses, because the post-conviction court is the one who gets to look those witnesses in the face, gets to see their demeanor, and gets to judge whether they're telling the truth.
And what were the operative findings?
The post-conviction court accredited counsel and did not.
Over that of the petitioner?
Excuse me?
Over that of the petitioner?
Over that of the petitioner, to be clear. So even if counsel were correct and that it could convince this court that the trial counsel was not entirely credible, there's no finding here that the petitioner was credible in his testimony. He was not credible.
Counsel, let me ask you this. I mean, you're certainly correct on your analysis of the credibility determination, the effect that has on our review. But I was struck by the one point in the petitioner's brief where he talks about whether he was going to testify or not, and how that was sort of, at issue and contested between him and his attorney. But it is true, I think, and the record will of course bear this out, that the attorney did say at trial, I'm going to call my client. Will that be this afternoon or will that be tomorrow morning? Was there any explanation at the PC hearing as to why she would have said that if her testimony was, I never intended to call him?
Her testimony was that up until that point, he had insisted that he didn't want to testify, and then at that point, he then briefly decided that he wanted to, and then changed his mind again. Was her explanation for that. And that is the explanation that the post-conviction court credited, and specifically did not credit the petitioner's explanation. So as far as the IEC claims here, and to just right off the bat, to clarify here, there is some overlap between the IEC claims and this standalone claim, and I want to be perfectly frank with the court. The post-conviction court did not really address this as a standalone claim. I think it saw it as part and parcel of the IEC claim. I understand that, but I think if we look at the petition, it is a freestanding claim. It's one the post-conviction court should have found to be waived. Unfortunately, it was never addressed as a freestanding claim at all. But it's in the petition.
No, but it affects the lens through which we view the issue. So it might be different if we're viewing it as a standalone claim on the merits versus through the lens of the Sixth Amendment, which requires deficient performance and prejudice.
Absolutely, but I think this court, this is as you pointed out, Judge Greenholz, this is the kind of, that lens is important, and that's why we have it baked into the post-conviction statute the concepts of post-conviction waiver and previously determined. Here, the petitioner certainly could have waived raised the specific Momon issue in a motion for new trial or on appeal, and did not. And I think had the post-conviction court directly confronted this as a standalone issue, it would have found it to be waived, and this court should do the same. To the extent that there is a Momon issue here, I want to be clear, there was a Momon hearing, and the petitioner was informed of his rights and indicated that he understood them. The only sort of wrinkle here is that there was sort of a change of heart the next day that was conveyed by counsel. But getting back to the ineffective assistance claims, 'cause I don't want to fail to address those. We've got sort of three varieties here. We've got a pretrial preparation claim. This is one of those claims that is entirely dependent on credibility findings. Essentially, you have trial counsel stating, I was ready to go to trial when we went to trial. And the petitioner's asking you to discredit that. The post-conviction court accredited that testimony, and there's no indication here that counsel was in any way unprepared to go to trial when they went to trial. Talking about the petitioner taking the stand. Again, this is another claim that is largely dependent on the testimonies and weighing those, which the post-conviction court did, and an accredited trial counsel who said, this was the petitioner's choice, this is what the petitioner decided to do. Opening testimony is a little different. This was the one that's not really resolved on the credibility issue. Counsel, conceded that she indeed made a misstatement during opening arguments about hearing about petitioner's reasons for having a gun. But this is not this is not directly like the Zimmerman case. Not all unfulfilled promises during opening arguments are reversible.
So how is this distinguishable from Zimmerman?
So in Zimmerman, you're promising essentially we're going to put on this expert that's going to explicate our theory of the case. This is what our case rises and falls on.
And then you don't call the expert?
And then you don't call the expert.
Right.
Here, this is an sort of a loose statement. You shouldn't have made it. But this was, to be clear, the strategy going into this was essentially to concede the gun in hopes that the jury would allocate the gun to the petitioner and the drugs to his passenger. Now, in hindsight, that strategy didn't work, but that was the strategy. So ultimately, it didn't really matter why he had the gun, and I think everyone at this post-conviction hearing acknowledged that him being scared or anything like that would not have justified a felon. I mean, it's felon possession charge. Outside of maybe an active self-defense situation where you pick up a gun that someone has dropped and defend yourself against gunshots, it doesn't really matter for felon possession why you have the gun. So this was simply a loose statement. It was not one that counsel should have made, but it certainly didn't rise to the level of ineffective assistance of counsel. And then turning back to the Momon issue, I think I got out of order and addressed most of what I have to say on that. I believe the briefing also addresses an issue of cumulative error. It's the state's position that there is no error here, so there certainly can be no cumulative error. If this court has any questions, I'd be happy to.
It's not that there's no errors, that there's no deficient performance.
Sure, there's no singular instance of ineffective assistance of counsel. So so we have essentially 3 separate allegations of ineffective assistance of counsel and the standalone claim, none of which have merit. Thus, we don't have cumulative error because none of those individual alleged errors exist. So if there are no further questions, I would ask this court to affirm the judgment of the post-conviction court. Thank you, Your Honors.
I'll start by correcting a couple of misstatements that I heard. Counsel did not address a change of heart the following day. There is nothing in the record to indicate that Mr. Brown changed his mind about testifying. There is nothing in the record to indicate that trial counsel had any conversation with Mr. Brown to announce such a change of heart. But most importantly, there's nothing on the record indicating that any conversations were had or that any additional moment hearing was conducted. The only thing we hear or we find in the record is the following day, trial counsel stands up and says that she rests. That's it. There's no other discussion with Mr. Brown. So it would be completely unfair to say that it was addressed at all. on the record.
Did she say anything at the PC hearing about what happened there? Why she said one thing and did another?
She claimed that she and her investigator went to the jail and spoke with Mr. Brown, and he changed his mind, which, again, would be another contradiction to her testimony that he had never planned on testifying. If he had never planned on testifying, then she wouldn't need to go down and speak with him to convince him to change his mind. It's just inaccurate. Additionally, I believe her initial testimony was that there was a break, a recess after Momen hearing, where they discussed it in the court. And it wasn't until she was confronted with the fact that there was an overnight recess that she came up with, that she testified that she had this discussion with Mr. Brown. There's also no evidence that she or her investigator actually went to the jail, signed in, and met with him that night. And once again, Mr. Brown said that that did not happen, and that was not true, and he never changed his mind. Obviously, the trial court made their credibility finding trial counsel credible, but that determination is not owed deference when there is ample evidence and direct contradiction to the trial court's finding. This isn't an instance where there are minor discrepancies. This is an instance where there are major issues. Her client's guilt, her client's possession of the gun is at issue, and she never conceded error at the post-conviction hearing. She maintained at the post-conviction hearing that Mr. Brown told her he possessed the gun. It was in the video. He possessed the gun. He admitted possessing the gun. She maintained that throughout. She never conceded error. And she claimed that it was her strategy to take ownership of the gun, and the co-defendant was going to take ownership of the drugs, and then they'd split the baby. That makes no sense. That's not a reasonable trial strategy based on reasonable investigation, because Mr. Brown was a felon. His co-defendant was not. If they wanted to split the baby, it makes more sense for the person legally allowed to own the gun to take possession of the gun. But even if we believe that that's true, co-defendant's attorney testified at the post-conviction hearing and testified that they never had strategy sessions, that they never discussed a joint defense. And co-defendant's counsel's opening statement and his entire strategy throughout trial, including when he called his client to the stand, belies her statement that she believed that this was their joint defense, was that they were going to split the baby, because she was sitting there when co-defendant testified and denied ownership of the gun, or the gun and the drugs. So at that point, a reasonable and effective attorney would have at least changed their strategy if that was, in fact, their pretrial strategy. You must adapt to the unknown. You must adapt to changes. And she did not. And instead, she repeated in her closing argument, yes, Mr. Brown possessed this gun. He admitted to possessing this gun, but you didn't hear why. It doesn't matter, because he never, ever claimed that that gun was his. So we'd ask that you reverse the trial court and remand for a new trial. Thank you.
Thank you. All right, we're going to take a few-minute recess before we take up the next case.